Welcome back to another video. Now in this video I'm going to talk very briefly about the duties of constructive trustees. So once you are determined to be a constructive trustee, what are your duties or responsibilities? It would, after all, perhaps seem a little unfair to apply all the duties of a normal trustee when they are likely to have no idea they are in fact a trustee. So as a constructive trustee, you may not know you're even a trustee at all, so it may not seem fair to have all the responsibilities and duties of a normal trustee. So the question is then, what duties do apply to a constructive trustee? So they are under no obligation to invest or to observe the usual duty of care. So they don't go to the level of the expressly appointed trustee, as this would be unreasonable as they don't know they are a trustee. It would be unreasonable to impose such obligations in cases in which they did not know that they were a trustee, as I just mentioned. And the duties in general haven't actually been made clear. It's not entirely clear what duties specifically a constructive trustee has. But we do know that these obligations and duties of a constructive trustee do vary by circumstances. So the duties of a constructive trustee haven't been made clear, and they probably do vary by circumstances, and they will be greater for a fraudulent trustee than for others. Now, Professor Burks explains a little bit more in Privacy and Loyalty. He says that there is an obligation on the constructive trustee to convey the trust property to or to the order of the beneficiary. So once the constructive trustee knows they are a trustee, then they need to take the right responsibility and give the property to the right individual. A breach of this obligation would create a personal liability. So if they find out that they are a constructive trustee and refuse to give the property to the person it belongs to, then they will be in breach and therefore they will be personally liable. But the trustee cannot, without fiction, be said to have assumed obligations of the utmost selflessness. So, in other words, as I've explained a couple of times now, it's not the same high standard of the express trustee, okay? They're not to be held to the same duties and responsibilities and the same standard as that of an express trustee. The only way to reach the contrary conclusion would be to say that this is the technique of equity, to subject trustees, even unwilling ones, to the fiduciary standard so as to generate the corresponding liabilities. So again, because of fairness, we will not hold the constructive trustee to the same standard as an express trustee. That, however, would be using the fiduciary relationship in a wholly instrumental way. So with the fiduciary relationship, there is a relationship of trust and confidence that has to be established. But if you have a constructive trustee, then you don't really have that. So it would seem absurd to impose that trust and confidence standard. So, as they don't know they are a trustee, you can't hold them to that same standard. So, just to recap, in general terms, the office of trustee under a constructive trust is necessarily different from that under an express trust. The parties will not necessarily know with certainty whether or not a constructive trust exists until a court declares that such a trust does in fact exist. What is suggested here is that in the real world, the very existence of a constructive trust will often be contested until the court makes an order declaring that it does exist. What is therefore at issue is the liability which ought to attach to the constructive trustee for the period between the time when the constructive trust came into existence and the time at which the court made the order confirming its existence. Now, we do know in theory the office of trustee will arise as soon as the trustee has knowledge of some factor affecting her conscience, because constructive trusts are in general institutional trusts. What remains unclear is the extent to which a constructive trustee would be liable, for example, for a failure to make the best possible return on a trust investment and so forth, as would be required of a trustee under an express trust. Now, as Millett put the matter in the case of Fayed number 2, it is a mistake to suppose that in every situation in which a constructive trust arises, the legal owner is necessarily subject to all the fiduciary obligations and disabilities of an express trustee. Okay, so the obligation to be imposed on a constructive trustee will therefore depend on the context of the case. Okay, they will generally extend to stewardship and maintenance of the property to the beneficiary's account, but they'll probably not extend to positive obligations as to investment of the fund in all circumstances, particularly given that there will not be any sort of detailed written provisions of such a trust. So that is a very general overview of the obligations and duties. It's very difficult to be specific because it does change depending on circumstances, but the crux of the matter is they won't be held to the same standard as an express trustee. Now, if you have any questions at all, then please do leave your comments and questions below and I'll get straight back to you. If you enjoyed the video, then make sure you give it a thumbs up and subscribe to my channel. Thank you very much for watching.